Return to your old job in South Korea. Part 2. The example of a former employer hit with a suit. In June 2010, an employee was laid off. In September 2011, about a year and a half after that, his former employer hired a person to do the same job that had been previously done by him. And in doing so, his former employer didn't get in touch with him to let him know about the job opening. At that time, when his former employer was in the process of hiring someone else, he remained unable to get a new job. When he became aware of that, he was shocked it had happened. He thought he had missed out on going back to his old job and that something had to be done to take back what had been taken from him. When he called to tell his former employer, the former employer offered a one-sentence reply: "My attorney will be in touch." So he engaged a lawyer and filed a lawsuit against his former employer. In that court case, the lawyer representing him said that although there are no statutory guidelines that must be complied with by a former employer when hiring someone to do the same job that was previously done by his former employee, the former employer should be seen as having a duty to reach out to his former employee to see if he's interested in working again for him before he hires someone else. According to the logic of this argument, the former employer in question had a duty to get in contact with his former employee to let him know about the job opening and failed in that duty. But for the breach of duty, the former employee in question would have asked his former employer to let him take back his old job in compliance with the law, and he would have had income from the employer since the day he started to work again for the employer. The breach of duty caused the former employee in question to suffer loss of income, and the loss of income was a foreseeable consequence of the breach of duty. In contrast, the lawyer representing his former employer said that there is no statutory basis for a former employer to have to make a point of getting in touch with each of his former employees one at a time to let him know about the job opening. According to the logic of this argument, the former employer in question had a duty to agree to let his former employee work again for him only when asked to do so by the former employee who was somehow aware of the job opening. The former employer in question did nothing to be considered a breach of duty until after he was asked to let his former employee work again for him. Who did the Korean Supreme Court decide was right? The court accepted the former employee's claim that a former employer should be seen as having a duty to get in touch with each of his former employees one at a time to see if the former employee will be interested in working for him again before he hires someone else to do the same job that was previously done by the former employee. The court found that at the time of hiring someone else, the former employer in question didn't get in contact with his former employee, even though he didn't have an excuse to believe that the former employee didn't want to go back to his old job. On September 26, 2020, the Korean Supreme Court ordered the former employer to pay the former employee a significant sum of money in damages for the breach of duty.